Namaste. Thank you for your gracious remarks. Well, I had an associate working with me. He was a former journalist, Mr. Dhananjay Mahapatra. Biraja Mahapatra, sorry. Other than that, my interaction with the journalists has hardly been there during my tenure as a lawyer for about 20 years, and then 23 years as a lawyer and 20 years as a journalist. This perhaps is the first occasion where I've interacted with so many journalists. And I consider it to be my privilege addressing the gathering of the Editors Guild of India. Many congratulations to the two winners, Parth Emin and Joseph. The subjects chosen, both environmental law and political, not environmental journalism and political journalism, are very appropriate. I must also thank the persons on the chair, the ones who have put in a lot of hard work to select the recipients. Ms. Rami Chabra, she was a journalist when I was still in school, and she continues to have the same vigor. And also Ms. Sunita Gupta, who's a journalist, I was told, working with Hindustan Times, and she continues to carry on even at this age. Our institutions, yours and mine, do not often share the stage. However, we carry the same calling, a calling to act as a watchdog institution in the service of the common citizen. In essence, we are both truth seekers, though we follow different paths. Therefore, when I was asked to address this gathering, I chose the topic Judiciary and Media, Shared Principles, Similarities and Dissimilarities. 75 years after India's independence, the question before us is not whether we possess freedom, thought and expression, but whether the freedoms to speak have grown more capacious, more inclusive, and more resilient. Has it widened its arc to accommodate new voices, deeper dissent, and evolving modes of discourse? Has it responded meaningfully to the demands of the present days? At the heart of our democratic conversations stands the right to free speech and expression. It is a right as fundamental as the most important right, the right to life, and there is a reason for that. The freedom to speak and expression enables all other rights. And yet, at all time, it faces challenges from within and outside, from political and the executive overreach, digital distortion, economic vulnerability, and even public fatigue. The press and the judiciary are two sentinels of our democratic order. Both act as a check on the excesses of executive and the legislative power. They also act as a check on social wrongs. Media more directly, we in the judiciary in a more nuanced manner. Both, when functioning well, speak truth to the power, not to provoke, but to preserve and strengthen democracy. After all, a political and social order that works for the people, by the people, and of the people necessarily implies robust watchdog institutions. Our legitimacy stems not from any election, but from public trust and faith. The people's trust rests on the belief that we are guided by reason, integrity, and impartiality. Like measures held onto power, our institutions reflect the state of governance and rights in the country. But if the mirror cracks through bias, misinformation, or loss of independence, the reflection itself becomes distorted. Rights are the casualties. Hence, both our professions require steadfast commitment to neutrality, fairness, and objectivity. We must erect guardrails against prejudice, keeping into our institutions and structures. Bias can creep in quietly, but can be judged in the framing, in the language, and selection of views. It can be gathered from the projection of news and the opinion in the judgments. For both of us, discipline lies in recognizing and resisting bias and prejudices. We are also by design diverse and polyvocal. In the courtroom, divergent views find expression through dissents, overloading, and concurrence. In the newsroom, it appears in diverse editorial views and reportage. This plurality is not a flaw, it is a foundation to the character of our institutions. No institutional tasked with protecting liberty can afford to be a single unitary voice. If that becomes the case, nothing will separate rationality from propaganda. What is propaganda? Propaganda is done to plant ideas and manufacture consent. Propaganda has a tendency to rupture democracy. Judgments do have impact on society, but news reporting can change the way we think and behave. We underestimate the impact of news. News coverage is not benign source of facts, but subconsciously meddles with our life. We may not realize we are constantly simmering in a soup of news. This is also where I like to highlight the difference between toxic news and healthy news. While there is no rigid or agreed upon definition for toxic news, the word toxic refers to the idea of pollution. Water is toxic if it has critical oxygen deficit created by pollution. In democratic society, news or media reporting is healthy only when the reporting is not polluted by prejudice, bias, or polarization. Healthy democracy needs news media which ensures effective traffic of ideas among participants. It is more effective when the participants sift through multiple positions and identify the ideal aspect or solution to the issues they face. Discussion must articulate the views, and the viewers must have the capacity to listen, understand, and negotiate each other's point of view. We must make use of language which is respectful and not denigrating or threatening. It should not pour fuel into sites of active conflict, making it greater. It must be mindful of the dignity of citizens' identity. Over time, constant toxic exposure can narrow minds and create echo chambers where the same views are repeated and reinforced. Minds become narrower. Cliques form of mutual and long-term reinforcing point of views. Consequently, when toxicity prevails, democracy loses its fidelity and ability to govern with legitimacy. And finally, both the judiciary and the press serve as conduits to public grievance. We listen and act differently. You through stories and articles, we through pleadings, oral arguments, and written judgments. But our purpose converge: to protect the voice of truth, be fair and objective. When we do so, we uphold the freedom and liberty. Facts and opinion are not the same. This distinction matters as much for the media as it does for the judiciary. In the court, we seek the truth, apply the law, deliver the judgment. If the facts are false or incomplete, the decision will be flawed. Falsehoods and half-truths lead to wrong outcomes. Responsible reporting tells the full story without inflaming passions or narrowing public debate. It represents a range of perspectives, avoids hidden agendas, and resists the subtle art of framing or priming. Judges reach balanced conclusions by weighing all sides before speaking through reasoned judgments. Journalism should strive for same discipline and standard. Accuracy and fairness are non-negotiable. Truth, perspective, critical thinking are the shared ground on which justice and a free press stand together. While one will agree that there cannot be any absolute or universal truths, most of the time they are relative truths shaped by language, culture, and concepts, and that relativism has its merit, but it should be based upon a firm foundation. This foundation must represent relative ideas, but never with the intent of mind to manipulate or sensationalize journalism. News reporting will be fair when it tells a story it tries, it accommodates different viewpoints. It should not promote a narrow viewpoint or to inflame. It should not have an agenda setting. The media should not engage in framing and priming, that is, taking up certain issues and influencing the public, and to influence the criteria by which the public evaluates particular matters. Media has to engage in dialogue and critical thinking. Despite these shared burdens, there remain certain crucial distinctions between our two institutions. Media is an institution for creation of opinion. There you stand head and shoulders above judiciary. Judges, as constitutional functionaries, we respond to facts on record, interpret the law, and speak through our judgments. We do not choose our cases, nor do we comment on them outside the courtrooms. We must not and should not editorialize. Any constitutional functionary who chooses to do so betrays the oath to judicial life. The media rightly exercises, as I said, greater speech freedom. It may raise any issue, adopt any editorial stance, and frame narratives. Today, there is much debate about regulation, if not control of the media. But to truly grasp the contours of the censorship discussion, we must first look into the history. Barely a year after the Constitution came into force, the Republic was confronted with the first major constitutional reckoning. In Ramesh Thapar and Brij Bhushan, the Supreme Court firmly expressed its view that there should not be any restrictions on the freedom of speech and expression other than those mentioned in Article 19(2), and thereby made it clear that there could not be an interference with the freedom of speech and expression in the name of public interest. For the government then, however, the implications were somewhat unsettling. With the wounds of partition still raw and the memory of communal rights fresh, there was growing concern that speech, especially provocative or inflammatory expression, would destabilize the social fabric of India. In response, the government introduced the first amendment to expand the grounds of permissible restrictions under Article 19(2). This amendment added the words public order, friendly relations with foreign states, and excitement to an offense as new grounds for limiting speech. On the face of it, it was a regressive turn. It enlarged the state's power to censor and control, but it also introduced a critical safeguard: the requirement that such restrictions should be reasonable. This single term, hard won and bitterly debated, became the bridge for the constitutional accountability. The passage of the First Amendment sparked significant political resistance. More than 75 members of the Parliament demanded a free vote on the issue. Ministers began to insist that the phrase reasonable restrictions must be inserted to preserve judicial oversight. Without it, many believed that the amendment threatened to strip Part 3 of the Constitution of its teeth, granting Parliament unchecked authority to curtail fundamental rights. A contemporary news report described how the Cabinet had decided to meet the mounting criticism by rendering a new restriction justiciable, subject to judicial review and not beyond constitutional scrutiny. Judiciary, on its part, took the mandate seriously. In the later cases like Indian Express and Sakal papers, Supreme Court built out the meaning of reasonable, insisting that any restriction must be fair, just, and non-arbitrary, and proportionate to the objective pursuit. Over time, this matured into a constitutional doctrine. Reasonableness requires a restriction to serve the legitimate aim, two, to be narrowly tailored to that aim, and three, not disproportionately infringe on what scores right. Reasonable restrictions permitted under Article 19(2) are neither rigid nor formulaic. They are inherently contextual and must evolve with the time. Their elasticity is deliberately crafted to accommodate the tensions and contradictions of a plural democratic society, and this is a very flexibility demands constitutional vigilance. Courts must guard against temptations to censor merely because speech is uncomfortable, inconvenient, or unsettling to some. As it has been said, and I quote, "Freedom to think as you will and to speak as you think are means indispensable for discovery and spread of political truth. The greatest menace to the freedom is inert public discussion is a political duty." These words echo and are relevant even today. Indian Supreme Court, in the celebrated judgment of Shreyas Singhal, had laid down foundational framework, what remains essential to recall. The court made it clear that so long as speech remains within the realms of discussion or even spirited advocacy, no matter how unorthodox or unsettling, it lies at the core of Article 19(1)(a) and must be constitutionally protected. Only when the expression graduates into incitement, posing a tangible threat to public order or any other legitimate interest, do the restrictions under Article 19(2) properly arise. In doing so, the court underscored that Constitution does not grant the state, and indeed the judiciary, a license to become arbitrators of praise, satire, or social decorum. The responsibility of the constitutional adjudication lies not in endorsing a majoritarian morality, but in upholding the dignity and autonomy of the speaker, even when the words may offend, provoke, or disturb. Freedom of speech is an autonomy and a dignified right, grounded on individuals' capacity to think, choose, and speak freely. Its protection is not only essential for personal fulfillment, but also for our collective search for truth in a democratic society. The utility of freedom to speech is captured well in the judgment in the case of S. Rangarajan, wherein it has been observed. Democracy is a government by the people via open discussion. The democratic form of government itself demands from its citizen an active and intelligent participation. Public discussion with people's participation is the basic feature and the rational process of democracy, which distinguishes it from other forms of government. Article 19(1)(g) of the Constitution guarantees the freedom to practice any profession and to carry on any occupation, trade, or business. For the media, this encompasses the freedom to raise capital, publish across platforms, and grow independently. Restricting this freedom weakens both democracy and our economy. The media often is the first to uncover errors in public functioning. If we silence that voice, we lose the key instrument of democratic correction. Nearly a century back in 1919, Justice Oliver Wendell Holmes' dissenting opinion in defense of free speech principles coined the phrase marketplace of ideas. He had argued the best rule of truth is the power of thought to get itself accepted in competition in the market. He rejected the test of clear and present danger to curtail the right to thought and speech with the expression that danger must be clear and imminent, and not merely a potential or an abstract threat. A little earlier, in the late 19th century America, two rival newspapers, New York World and the New York Journal, were engaged in a fierce circulation battle. In their race for leadership, they pioneered what would be known as yellow journalism, a style marked by exaggerated headlines, emotional appeals, half-truths masquerading as reporting. The term itself arose from a Yellow Kid cartoon used to lure readers, but the word soon came to symbolize a deeper decay, prioritizing of attention over accuracy. The lessons from that area remain relevant today. In time when the speed runs over substance and vitality often overruns verification, we must guard against new avatars of yellow journalism, whether they're in gap of ideology, entertainment, or logic or mathematical application. Democracy that loses its fidelity to facts soon begins to lose its ability to govern with legitimacy. I was reading some time back a short article by Komi Kapoor, who is a journalist of considerable repute, and she had referred to three important or essential foundations for free press. The first was the media must be financially stable and free from dependence on government largesse. The second was the media must not be entangled with business interests that will come in conflict with its role as a purveyor of truth. The third was, and fairly crucial, that the government's accessibility must be made available to the media. We are today living in a world where the social media has come to stay and perhaps is the main media. The legacy media has come down in terms of eyeballs and the user's preference. Obviously, social media has its advantages, therefore it's become so popular. One of them being it doesn't require substantial investment, and it's easy to upload, and people have access all over the country at minimal or no costs. Obviously, this means greater democracy within the media itself. But then, this also gives rise to certain problems. Majority of the people today receive news selected by algorithms based upon their past interest or what someone will like to think. Unlike the print media, where the user reads, assimilates, and reasons, social media thrives on speed of information dissemination and the magic bullet theory, short bullets of information. This has its consequences. Firstly, the combative capacity of the user gets diminished. Thinking in depth requires effort and energy. Social media is attractive, and many or most of the time it does not require competitive capacity and time. Today, the youngsters do not have sustained ability to think about complex topics. Cognitive reasoning is declining. Its consequences are the best ideas do not rise to the top. Ideas that carry a majority support get upvotes based upon familiarity or position, emotional silence, and so on. Secondly, controversial topics often result in exchange of heated comments. Look at the TV debates today. No topic is truly safe. We witness flame wars every evening. Acrimonious exchange online do not result in bridges being built. Instead, they tend to intensify the anger and vitriol and the increase abusive and intolerant position amongst the participants as well as the viewers. For our community to be cohesive, we as citizens should be able to discuss issues such as politics, religion, gender, etc., without combative interactions by discussing them calmly. The third consequence is quantity becomes quality. The disparity in position creates a sense of being hounded by popular opinion and eventually results in the users with minority views exiting the community. Populist views become the norm and shake people's behavior and thinking. There is a spiral of silence as those having minority views are less likely to speak out of fear of social isolation. Individuals tend to rely upon self-selected information consistent with their prior beliefs, which gets exaggerated into personalized fields. I think I've taken a lot of time, so I'll come to the last portion, which again will now refer to the interaction between the judiciary and the media. Judiciary and the press are two different and distinct organs, but our health is interdependent. Constitution gives each one of us a separate role. Neither must we usurp the other. The judges must remain within the four corners of their brief. The media must remain free but fair. Our institutions do not need applause. We need credibility and faith. That comes not by being always right, but by being principled. To the end, I like to borrow and tweak a few words from Rabindranath Tagore. The minds and souls of journalists and judges must always remain free. We must operate without fear, bias, or prejudice. For it is when our institutions are free and fearless will our nation be held high. Thank you and Jai Hind.